Before we begin, a quick and important disclaimer. The information provided in this video regarding the intersection of Islamic religious practices and United States civil law is for educational and entertainment purposes only. It does not constitute professional legal, financial, or religious advice. Family law is a complex field that varies significantly from state to state, and religious interpretations can differ based on various schools of Islamic jurisprudence. Viewers are strongly advised to conduct their own due diligence and consult with qualified legal counsel and recognized religious authorities regarding their specific individual circumstances. You are legally divorced in the eyes of the United States government, but in the eyes of your faith, your community, and your Creator, you are still married. This is the phenomenon of the limping marriage, a legal and spiritual purgatory that thousands of American Muslims find themselves trapped in every single year. Imagine walking into a secular courtroom in Virginia or California where a judge, who may have never opened a Quran, is tasked with deciding the validity of a contract written in Arabic 15 years ago. This is not just a breakdown of a relationship. It is a high-stakes collision between two entirely different legal universes. One system views marriage as a civil contract governed by state statutes, while the other views it as a sacred covenant with eternal consequences. Today, we are pulling back the curtain on the most misunderstood, stigmatized, and legally complex transition in the American Muslim experience. We are going beyond the surface-level conversations to explore how Sharia and the U.S. Constitution interact, why your marriage contract might be your greatest asset or your biggest liability, and how the landscape of divorce is shifting for a new generation of believers. The problem we are solving today is the information gap that leaves so many individuals vulnerable during one of the most stressful periods of their lives. For many in the U.S. Muslim community, the process of ending a marriage is shrouded in cultural shame and legal ambiguity. You might be wondering if your mahr is enforceable in a U.S. court, or if a civil divorce automatically counts as a religious divorce. You might be concerned about how a judge will view your religious upbringing when deciding child custody. By the end of this masterclass, you will have a comprehensive understanding of the historical trends, the potential outcomes of complex litigation, and the step-by-step nuances that define the modern divorce process in this specific cultural context. We are moving past the myths to provide you with the deep-dive clarity required to navigate both the courthouse and the community center with confidence. To understand divorce in Islam within the American context, we must first analyze the foundation, the nikah or the marriage contract itself. In the United States, most Muslim couples engage in a dual process. They obtain a civil marriage license to ensure their union is recognized by the state, and they perform a religious ceremony to ensure it is recognized by their faith. However, the document signed during the religious ceremony, the nikah, is often treated as a mere formality or a ceremonial keepsake. This is a critical oversight. In the eyes of many U.S. courts, this religious document can be viewed as a prenuptial agreement. The implications of this are massive. For example, consider the mahr, which is the mandatory gift from the groom to the bride. It is often divided into two parts: the prompt mahr, paid at the time of the wedding, and the deferred mahr, payable upon death or divorce. In a U.S. divorce proceeding, a spouse might argue that the deferred mahr is a binding debt that must be paid on top of any state-mandated, equitable distribution of assets. Historical trends show that U.S. courts have struggled with how to handle these claims. Some judges have historically dismissed the mahr as a religious gift that falls outside the jurisdiction of a secular court, citing the First Amendment's Establishment Clause. However, a growing body of case law suggests a shift toward the neutral principles of law approach. This means that if a court can interpret the Islamic marriage contract using standard contract law, looking at offer, acceptance, and consideration, without delving into religious dogma, they may enforce it. This creates a fascinating and often volatile legal environment. If the mahr is set at $50,000, is that a reasonable settlement, or is it an unconscionable burden? If the contract was signed 5 minutes before the ceremony under the pressure of 200 waiting guests, can a lawyer argue it was signed under duress? These are the granular details that determine the financial future of individuals caught in this cross-section of law. Beyond the financial mechanics, we have to address the procedural divide. In Islamic jurisprudence, there are several pathways to divorce, such as Talaq, which is initiated by the husband, and Khula, which is initiated by the wife, usually involving the return of the mahr. In a traditional setting, a local mufti or an Islamic council would oversee these proceedings. But in the United States, these councils have no civil legal authority. This creates a massive point of friction. A woman might obtain a civil divorce from a state court, granting her the legal right to remarry and a fair share of marital property. Yet, if her husband refuses to grant her a religious divorce, she remains religiously married in the eyes of her community. This can lead to social ostracization and prevents her from entering a new religious marriage. This specific scenario has led to the rise of specialized arbitration services and the inclusion of specific clauses in American NICA contracts that stipulate a civil divorce will be recognized as a religious one. We must also examine the shifting demographics and social attitudes within the U.S. For decades, divorce rates in the American Muslim community were significantly lower than the national average, often due to the intense cultural stigma associated with a failed marriage. However, recent data and case studies suggest that the gap is closing. This is not necessarily an indication of declining values, but rather a sign of a community that is becoming more legally literate and less willing to tolerate domestic dysfunction. Younger generations, particularly those born and raised in the U.S., are approaching marriage and divorce with a more egalitarian lens. They are more likely to seek professional mediation and are more comfortable navigating the secular legal system to protect their rights. This shift is forcing religious institutions to evolve, with many masjids now requiring proof of a civil marriage license before performing a nikah and offering more robust premarital and postmarital counseling. The complexity further intensifies when children are involved. U.S. family courts operate under the best interests of the child standard. While religious upbringing is a factor a judge may consider, it is rarely the sole deciding factor. This can lead to tension when one parent wants to ensure a strictly Islamic education or lifestyle, while the other parent, perhaps leaning toward a more secular or different interpretation, disagrees. We see case studies where parents must negotiate detailed parenting plans that account for religious holidays like Eid, dietary restrictions like halal, and the attendance of Sunday school. The ability to articulate these needs within the framework of U.S. law is a vital skill for anyone navigating this path. It requires a move away from emotional rhetoric and toward structured, evidence-based advocacy that respects both the legal system and the religious identity of the family. In this deep dive, we are also looking at the role of the community. In the U.S., the lack of a centralized religious authority means that different communities might handle divorce in vastly different ways. A community in Dearborn, Michigan with a high density of practitioners might have a very different support structure than a small isolated community in the rural Midwest. This geographical variance means that the potential outcomes for a divorce can be heavily influenced by the specific local council or imam involved. Some councils are progressive, seeking to protect the rights of women and ensuring that the religious process does not become a tool of abuse. Others may be more traditional, emphasizing the preservation of the family unit at all costs. Understanding these dynamics is essential for anyone entering this process, as the social and psychological impact can be just as profound as the legal ones. We are not just talking about the end of a legal contract, we are talking about the restructuring of a life, a faith journey, and a social network. This is part 1 of our masterclass, and we have only just begun to scratch the surface of the legal, spiritual, and social machinery that drives divorce in Islam within the United States. To understand the mechanics of divorce in Islam within the United States in 2026, we must look directly at the document that started it all, the Nikah. In the American legal system, this religious contract is increasingly being treated not as a spiritual artifact, but as a prenuptial agreement. This transition from the sacred to the secular creates a minefield of potential outcomes for couples like Michael and Jasmine, a fictional but representative couple living in suburban Illinois. Imagine if Michael and Jasmine signed their nikah in 2021 with a deferred mahr of $75,000. At the time, it felt like a symbolic gesture of Michael's commitment. But now, in 2026, as they stand on the precipice of a civil divorce, that $75,000 is no longer symbolic. It is a very real, very enforceable debt. The central conflict in U.S. courts often boils down to the First Amendment of the Constitution. Courts are generally prohibited from entangling themselves in religious doctrine under the Establishment Clause. However, historical trends show that judges have found a workaround called the neutral principles of law approach. This means the court will look at the nikah contract and ignore the religious headers, the Arabic calligraphy, and the mentions of divine blessings. Instead, they look for the 4 pillars of a standard contract: an offer, an acceptance, a consideration, and the capacity of both parties to enter the agreement. If these 4 elements are present, many states, including New York and New Jersey, have shown a willingness to enforce the mahr as a contractual obligation separate from the standard division of marital property. Let us look at a case study involving a 2026 dispute in California. A husband argued that his wife's claim to a $100,000 mahr should be dismissed because the contract was religious in nature. The court, however, applied the neutral principles doctrine. They determined that because the mahr was a specific sum of money promised in exchange for entry into the marriage, it functioned exactly like a civil prenuptial agreement. The husband was ordered to pay the full amount on top of the 50-50 split of their community property. This case highlights a critical point. In many jurisdictions, the mahr does not replace civil alimony or asset division. It is an additional liability. This leads to a scenario where a spouse could be financially devastated if they did not understand the legal weight of the document they signed in the mosque basement years prior. But what happens when the contract is signed under pressure? Imagine if, on the day of the wedding, the bride's family demands a mahr 5 times higher than what was previously discussed, and the groom signs it just to avoid a public scene. In 2026, U.S. lawyers are increasingly using the defense of duress and unconscionability. In contract law, if a document is signed under extreme pressure, or if the terms are so one-sided that they shock the conscience of the court, the contract can be thrown out. Historical trends in Virginia and Maryland have seen judges invalidate mahr agreements where the groom was only given minutes to review the document, or where the amount was so high relative to his income that it was deemed impossible to pay. This creates a high-stakes evidentiary battle where the testimony of the imam and the wedding witnesses becomes crucial. Step by step, the legal process usually begins with one party filing a motion to enforce or vacate the religious contract as part of the civil divorce. The court then holds a hearing to determine if the contract meets the state's requirements for a valid prenuptial agreement. In some states like Texas, the requirements are strict. A prenuptial agreement must be in writing, signed voluntarily, and must involve a full disclosure of assets. If the nikahnaमा was signed without Michael showing Jasmine his bank statements and tax returns from the previous year, a Texas judge might rule the entire mahr clause unenforceable under the Texas Family Code. This discrepancy between state laws means that the outcome of an Islamic divorce in the U.S. is heavily dependent on geography. Furthermore, we must address the concept of the Islamic arbitration clause. By 2026, many sophisticated nikah contracts include a provision that requires any disputes to be settled by a specific board of scholars or a Sharia council before or instead of going to a civil judge. While the U.S. legal system generally supports the right of parties to enter into binding arbitration, these clauses are often scrutinized. If the arbitration process does not provide the same basic due process protections found in a U.S. court, such as the right to an attorney or the right to present evidence, the civil court may refuse to honor the arbitration award. This creates a fascinating legal loop where religious councils must act more like secular courts to ensure their decisions are legally binding in the eyes of the state. The financial implications extend beyond the mahr. In an Islamic divorce, there is often no concept of permanent alimony or the long-term sharing of post-divorce income. However, in the U.S., a spouse may be entitled to spousal support for years. This creates a cultural and legal friction point. A husband might feel that by paying the mahr, he has fulfilled his religious obligation and should owe nothing more. Meanwhile, the state court may order him to pay $3,000 a month in alimony. Conversely, a wife might find that her religious divorce prevents her from seeking civil assets that she is legally entitled to under state law. This is where the strategic drafting of contracts becomes vital. In 2026, we are seeing a rise in Muslim couples hiring civil attorneys to sit alongside their imams during the contract signing to ensure that the religious and secular terms are harmonized. Data from recent sociological studies indicate that nearly 60% of American Muslim couples now include some form of civil legal language in their religious contracts. This trend reflects a growing awareness that the spiritual and the legal are inextricably linked in the diaspora. The stakes are particularly high regarding the classification of assets. In many Islamic traditions, property owned before the marriage remains the sole property of that individual. However, in many U.S. states, if that property is commingled, for instance, if Michael uses his pre-marriage savings to pay the mortgage on the house he shares with Jasmine, it can become marital property subject to a 50-50 split. Without a clearly drafted and legally recognized contract, the religious intent of keeping assets separate is often overridden by state law. This brings us to the psychological and social toll of these legal battles. When a couple is fighting over the validity of a nikah in a secular court, They are effectively asking a non-Muslim judge to weigh in on the most intimate aspects of their faith and culture. This can lead to a sense of betrayal and a breakdown of community trust. Case studies from 2026 show that these high-conflict divorces often spill over into the local masjid, with different factions taking sides based on their interpretation of the contract. The legal battle is not just about dollars and cents. It is a battle for narrative and religious legitimacy within the community. As we continue this deep dive, we have to look at the darker side of this intersection. What happens when the legal system is used as a weapon? What happens when one party uses the complexities of religious law to trap the other in a marriage that is dead in every sense except on paper? This leads us to the heart of the most painful part of the process: the difference between a civil decree and a religious release. You can have a paper from the state of Florida saying you are single, but if your religious community doesn't agree, your life can remain on hold indefinitely. In the next part, we will explore the mechanisms of Talaq and Khula in the US, the rise of the judicial divorce by American imams, and the controversial role of Sharia councils in ending a marriage when one party refuses to let go. We will look at how women in 2026 are finding new ways to reclaim their agency, and the legal strategies being used to break the chains of the limping marriage. The procedural reality of an Islamic divorce in the United States is often a two-track system that operates in parallel but rarely in perfect synchronization. While the state court handles the dissolution of the legal entity, the religious process addresses the spiritual contract. In 2026, the most significant point of friction remains the concept of the limping marriage. This occurs when a woman is civilly divorced under the laws of a state like Virginia or Texas, but remains religiously bound to her husband, because a formal religious dissolution has not occurred. To understand how this is being navigated today, we must break down the three primary mechanisms of religious divorce: Talaq, Khula, and Fash. The first mechanism is Talaq, the right of the husband to initiate divorce. Historically, this has been viewed as a unilateral right, but in the American context, its application has become nuanced. Imagine a character named Omar living in Michigan in 2026. Omar decides to file for a civil divorce. In many modern American Muslim communities, scholars and imams now argue that the act of a husband filing for a civil divorce or signing a final civil decree carries the implicit intent of a religious talaq. This is a significant shift in historical trends. Previously, many believed a husband had to explicitly pronounce the word 3 times or sign a specific religious document. However, to prevent the legal and spiritual limbo, many US-based councils now interpret the civil filing as a clear indication of intent to end the marriage. This prevents a scenario where Omar could claim he is still religiously married, just to exert control or avoid financial obligations. However, the reverse is not always true, which brings us to the second mechanism, Khula. This is the process initiated by the wife. Imagine if Omar's wife Sarah is the one who wants the divorce. In 2026, Sarah faces a different set of procedural hurdles. Under traditional interpretations, a khula usually requires the husband's consent, and often involves the wife returning her mahr or a portion of it as a financial consideration for her release. In a U.S. courtroom, a judge would likely find the idea of paying for a divorce to be inconsistent with modern family law. Yet, within her religious community, Sarah may feel compelled to negotiate. We see case studies where women give up their civilly mandated right to alimony or a share of a retirement account, just to secure the husband's signature on a religious divorce document. This is the high-stakes trade-off that occurs behind closed doors, often far from the eyes of the civil judge. When a husband refuses to grant a khula and the marriage is effectively over in every other sense, the third and most complex mechanism comes into play: fash, or judicial annulment. Because there is no formal state-sponsored Sharia court system in the United States, this role is filled by Sharia councils or boards of imams. Organizations like the Assembly of Muslim Jurists of America or local regional councils in Southern California, and the Tri-State Area act as quasi-judicial bodies. In 2026, the process of obtaining a fash is rigorous and step-by-step. First, the wife must file a formal petition with the council, providing her civil divorce decree as evidence that the marriage has legally ended. Second, the council will attempt to contact the husband to hear his side of the story and offer mediation. This is not just a formality. It is a procedural requirement to ensure due process. If the husband ignores the council or refuses to participate, the council moves to the third step, the investigation of darar or harm. The council looks for specific grounds such as abandonment, lack of financial support, physical or emotional abuse, or a persistent refusal to fulfill marital obligations. In 2026, councils are increasingly accepting psychological evaluations and police reports as evidence of harm, moving away from a strictly witness-based system. If the council determines that the marriage is causing ongoing harm and the husband will not release the wife, they have the authority to annul the marriage religiously. The potential outcomes of this process are highly dependent on the community's recognition of the council's authority. While a fash decree from a recognized council allows Sarah to remarry within her faith, it may not be recognized by more conservative or different sectarian groups. This lack of a centralized authority creates a fragmented landscape for American Muslims. Furthermore, we must address the legal risks for the imams themselves. In 2026, there is a growing trend of husbands suing Sharia councils for tortious interference with a marriage or defamation. This has forced many councils to adopt highly formalized, lawyer-vetted procedures that mirror the civil court system to protect themselves from litigation. One of the most innovative developments in 2026 is the use of the delegated divorce, or Talaq tafwiz. This is a clause inserted into the original nikah contract where the husband delegates his right of divorce to the wife, either unconditionally or upon the occurrence of certain events, such as him taking a second wife or committing a crime. While historically rare in the U.S., case studies show a significant uptick in its usage among professional, highly educated Muslim couples. This clause effectively bypasses the need for a Sharia council's intervention, as the wife can exercise the right herself. From a U.S. legal perspective, this clause can be argued as part of a binding prenuptial agreement, provided it was entered into voluntarily and with full disclosure. Step by step, the integration of these two systems is becoming more sophisticated. In 2026, many American masjids refuse to perform a nikah unless the couple also presents a civil marriage license. Similarly, they are beginning to require a civil divorce decree before they will even begin the religious divorce process. This synchronization is a defensive measure to prevent the legal mess of being married in one system and divorced in another. But even with these precautions, the human element remains unpredictable. Imagine a scenario where a husband, let's call him David, decides to use the religious process as a tool for financial leverage in the civil case. He might tell his wife that he will only grant the religious divorce if she agrees to waive child support in the state court. This is a form of religious coercion that American lawyers are now learning to identify and fight. In some states, such as New York, laws have been proposed to prevent a party from removing barriers to remarriage as a tactic in divorce litigation. This is a direct response to similar issues in the Jewish community with the get, but its application to Islamic divorce is a burgeoning area of legal practice in 2026. As we look at the data, we see that the time it takes to finalize a religious divorce in the U.S. can range from 3 months to several years, depending on the cooperation of the parties and the backlog of the councils. This delay can have devastating effects on a person's mental health and their ability to move forward with their life. The community is currently debating whether a civil divorce should automatically trigger a religious one, a move that would solve the problem of the limping marriage, but would require a massive shift in traditional jurisprudence. This procedural tension leads us to one of the most contentious aspects of the entire process: the role of the children. When the religious and civil paths diverge, the battle often shifts from the living room to the classroom and the prayer hall. How does a U.S. judge handle a parent's claim that the other parent is violating the religious spirit of the divorce? What happens when Islamic custody traditions, which often favor different parents at different ages, clash with the U.S. standard of the best interests of the child? In the next part, we are going deep into the heart of the custody battle, the secret world of religious mediation, and the specific strategies used by parents to maintain their faith traditions in a secular legal environment. We will explore what happens when the court-ordered visitation schedule conflicts with the Islamic calendar, and how 2026 parents are drafting the most detailed parenting plans in history to avoid these collisions. The intersection of child custody and religious upbringing within the United States legal system is perhaps the most emotionally charged and legally intricate chapter of an Islamic divorce. In the year 2026, the standard applied by every family court from New York to California remains the best interests of the child. This standard is intentionally broad, giving judges significant discretion to determine which parent can provide the most stable, healthy, and supportive environment. However, when this secular standard collides with traditional Islamic concepts of custody, known as hadhana and walaya, the result is a complex legal friction that requires a highly specialized approach to navigate. To understand this, let us look at a case study involving a fictional couple in 2026, Jennifer and Kareem, residing in New Jersey. They have 2 children, a 6-year-old son and an 8-year-old daughter. In traditional Islamic jurisprudence, the concept of had-hana generally grants physical custody of young children to the mother, recognizing her role as the primary caregiver during the formative years. Conversely, wilaya or legal guardianship often remains with the father, who is traditionally responsible for the children's financial maintenance, education, and overall protection. In a traditional setting, there is often a predetermined age, varying by the school of thought, at which physical custody might transition from the mother to the father. In a 2026 U.S. courtroom, this age-based or gender-based transition is virtually non-existent. If Kareem were to walk into a New Jersey family court and argue that he should receive primary custody of his son, simply because the boy has reached the age of 7, historical trends suggest he would likely lose that argument. U.S. law is gender-neutral and focuses on the actual bond and daily caretaking roles, rather than religious presets. For Jennifer and Kareem, this means the court will ignore the traditional titles of had-hana and wilaya, and instead look at who prepares the school lunches, who attends the parent-teacher conferences, and who provides the most emotional stability. The conflict deepens when we discuss the religious upbringing itself. Imagine if Kareem insists that the children attend a full-time Islamic academy to ensure they grow up with strong religious values, while Jennifer, despite being a practicing Muslim, believes the local public school offers a superior STEM curriculum and a more diverse social environment. In 2026, U.S. judges are generally reluctant to favor one religious lifestyle over another, but they are very interested in the status quo. If the children have been enrolled in an Islamic school for the past 3 years, the court is likely to maintain that enrollment to ensure continuity and stability for the children. However, if the parents cannot agree on a new school, the judge may award one parent the final tie-breaking authority on educational and religious decisions. This is known as legal custody, and in the U.S., it is increasingly common for parents to share joint legal custody, which necessitates a high degree of cooperation, a tall order in the middle of a high-conflict divorce. Step by step, the creation of a 2026 parenting plan for a Muslim family requires a level of detail that would have been unimaginable a decade ago. It is no longer enough to state that the children will spend alternating weekends with each parent. Modern lawyers must account for the lunar calendar. Imagine the logistical challenge of Ramadan. Because the Islamic calendar is lunar, Ramadan moves approximately 11 days earlier each year in the Gregorian calendar. A standard court order that grants the father every other weekend would eventually result in him missing the crucial nights of Laylat al-Qadr, or the celebration of Eid al-Fitr year after year. To solve this, 2026 parenting plans are being drafted with floating religious holiday clauses. These clauses specify that the religious holiday schedule takes precedence over the regular weekly schedule. They include granular details such as who has the children for suhoor, the pre-dawn meal, and who takes them to terawih prayers at the masjid. Case studies show that without these specific details, the police are often called to masjids on Eid morning because of a disagreement over whose turn it is to have the children. To prevent this, parents are now using specialized apps that track the lunar cycles and automatically update the shared digital custody calendar for the next 10 years. Another significant point of contention is the dietary and lifestyle requirements of the children. Imagine a scenario where Jennifer follows a strict halal diet for the children, but Kareem, during his weekend visitation, is more relaxed, allowing the children to eat at fast food restaurants that are not halal certified. While a U.S. judge is unlikely to hold a parent in contempt for feeding a child a non-halal chicken nugget, they will listen to arguments about the confusion and distress caused to the child when the rules change drastically between households. 2026 legal strategies often involve including a mutual agreement in the divorce decree that both parents will maintain the child's established religious dietary habits. This is not about the court enforcing Sharia. It is about the court enforcing a contract between two parents to ensure the child's psychological well-being is not compromised by conflicting household rules. We must also address the high-stakes issue of international travel and the risk of parental abduction. In the American Muslim community, many families have deep ties to countries that may not be signatories to the Hague Convention on the civil aspects of international child abduction. If a parent like Kareem has family in a non-Hague country, Jennifer might fear that a summer vacation could turn into a permanent move. In 2026, U.S. courts are taking these fears very seriously. Potential outcomes for parents in this situation include the requirement of a travel bond, a significant sum of money held by the court that is forfeited if the child is not returned, or the requirement that the traveling parent's passport be held by a neutral third party when they are not traveling. Some judges even go as far as to mirror image the U.S. custody order in the foreign jurisdiction's court before the child is allowed to leave the United States. Beyond the legalities, there is the role of the guardian ad litem or a court-appointed expert. In 2026, there is an increasing demand for cultural competency in these roles. A court-appointed psychologist who does not understand the importance of the Friday Jummah prayer or the cultural nuances of the extended family's role in a Muslim household might make recommendations that are unintentionally biased or harmful. Parents are now fighting to ensure that the experts assigned to their cases have a background in both secular child psychology and the specific cultural context of the American Muslim experience. This shift toward hyper-detailed, culturally aware legal planning is a response to decades of historical trends where vague orders led to years of post-divorce litigation. The goal for 2026 families is to create a roadmap that minimizes conflict and allows the children to maintain a healthy relationship with both parents and their faith. But what happens when the conflict isn't just about the schedule? What happens when the very foundations of the marriage contract, the financial promises made at the beginning, become the center of a scorched earth legal battle? This brings us to the next critical phase of our deep dive. We have discussed the children, but we have yet to fully tackle the financial fallout of the modern Islamic divorce. In the next part, we are going into the deep details of asset division, the battle over the mahr as a taxable event, and how the IRS and U.S. state courts view the transfer of religious dowries. We will explore how 2026 forensic accountants are tracing assets in a way that reconciles Islamic inheritance logic with U.S. community property laws, and why your choice of a financial advisor during your divorce might be just as important as your choice of a lawyer. The financial stakes are higher than ever, and the intersection of tax law and religious obligation is where many cases are won or lost. The financial architecture of a divorce in 2026 is where the spiritual contract of the nikah meets the uncompromising reality of the United States Internal Revenue Code. When a couple transitions from a shared life to separate existences, the division of assets is not merely a mathematical exercise. It is a complex negotiation of values. In the American Muslim context, this process is uniquely complicated by the existence of the mahr, the treatment of jewelry and gold, and the reconciliation of individual property rights under Islamic law with the community property or equitable distribution rules of the various U.S. states. To navigate this, one must understand that the IRS and state family courts do not necessarily recognize the religious categories of wealth, which can lead to significant tax implications and unexpected financial losses. Let us begin with the tax treatment of the mahr. Imagine a character named David, who is finalizing his divorce from his wife, Sophia, in early 2026. As part of their religious contract signed 5 years ago, David owes Sophia a deferred mahr of $50,000. David might assume that paying this amount is simply fulfilling a religious debt, but the IRS sees things differently. Under Internal Revenue Code Section 1041, transfers of property between spouses or former spouses incident to a divorce are generally non-taxable. However, the timing and the source of these funds are critical. If David pays the $50,000 before the final divorce decree is issued, it is typically viewed as a gift or a transfer between spouses. If he pays it after, it must be explicitly tied to the divorce decree to maintain its tax-neutral status. Potential outcomes for David could involve a significant tax bill if the IRS reclassifies the payment as a taxable gift because the paperwork was not filed correctly. Historical trends show that many couples fail to mention the mahr in their civil settlement, leading to a secondary, high-stakes dispute with the tax authorities later on. The battle over gold and jewelry represents another granular point of contention. In many Islamic traditions, jewelry given to the bride at the time of marriage is considered her absolute, separate property, intended to provide her with financial security in the event of death or divorce. However, in a U.S. courtroom in 2026, the classification of this gold depends heavily on state law. In a community property state like California, a husband's attorney might argue that the gold was purchased with marital funds during the marriage and should therefore be split 50-50. Imagine if Sophia has $50,000 worth of gold jewelry. In the eyes of her religious community, that gold is hers alone. In the eyes of a California judge, $25,000 of that value might belong to David. To protect these assets, 2026 legal strategies involve tracing the origin of the jewelry. Was it a gift from David's parents? Was it purchased with Sophia's premarital savings? Step by step. A forensic accountant must document the chain of custody for every ounce of gold to argue for its classification as separate property. This leads us to the broader challenge of tracing separate versus marital property. Islamic jurisprudence largely adheres to a system of separate property, where what a person earns or inherits remains theirs alone. This stands in stark contrast to the American concept of the marital estate. Imagine if David started a technology firm 2 years into the marriage using a small inheritance from his grandfather. Under Islamic principles, that business belongs to David. However, if David used his salary from the business to pay the family's mortgage, or if Sophia contributed to the household by managing their personal affairs, the business may be seen as a marital asset in a state like New York. Forensic accountants in 2026 now use sophisticated AI-driven software to perform what is known as a Van Camp or Pereira analysis. This involves calculating how much of the business's growth was due to David's personal efforts versus the natural increase in the market value of the initial capital. This level of detail is required because a U.S. judge will not simply defer to the Islamic principle of separate ownership. They require empirical evidence of how funds were used and commingled over the years. Retirement accounts such as 401ks and IRAs introduce another layer of complexity. Many practicing Muslims in the U.S. utilize Sharia-compliant investment vehicles that avoid interest-bearing instruments and certain prohibited industries. During a divorce, these accounts must often be divided through a qualified domestic relations order, or QDRO. A QDRO is a legal instruction to the plan administrator to pay a portion of the account to the former spouse. In 2026, we see case studies where the division of a Sharia-compliant account becomes a logistical nightmare. If the account is divided and the receiving spouse moves their portion into a traditional, interest-bearing IRA, it may create a religious conflict for the donating spouse who wants to ensure their wealth remains untainted by riba, or usury. Negotiating a settlement where both parties can maintain their religious investment standards while complying with the RISA laws is a specialized skill that few generalist divorce attorneys possess. Furthermore, we must address the issue of zakat and post-divorce financial obligations. Zakat is the mandatory almsgiving on accumulated wealth. During a divorce, the question arises: who is responsible for the zakat on assets that are currently frozen by a court order? Imagine if David and Sophia have $200,000 in a joint brokerage account that neither can touch until the judge signs the final order. If that order takes 18 months, thousands of dollars in zakat obligations may accrue. In 2026, sophisticated mediation agreements now include clauses that designate how religious tax obligations will be paid from the marital estate before the final split. This prevents a scenario where one spouse is left with a massive spiritual and financial debt that the other spouse refuses to acknowledge. Historical trends also show an increase in the use of lifestyle clauses in financial settlements. In 2026, some couples are agreeing to higher spousal support payments in exchange for the other parent's commitment to maintaining a specific religious lifestyle for the children, such as continuing enrollment in an expensive private Islamic school. While a U.S. court cannot easily enforce a purely religious behavior, it can enforce a financial contract where the payment of tuition is a condition of the settlement. This is a pragmatic, albeit complex, way that American Muslims are bridging the gap between their faith requirements and the secular legal system. The financial fallout of an Islamic divorce in the U.S. is also heavily influenced by the presence of international assets. Many families hold property, businesses, or bank accounts in their countries of origin. Tracing these assets requires international forensic accounting and an understanding of the legal treaties between the U.S. and countries like Pakistan, Egypt, or the UAE. If David has a family villa in Dubai, a U.S. judge may not have the jurisdiction to force its sale, but the judge can award Sophia a larger share of the couple's U.S.-based assets to offset the value of the foreign property. This is known as an equalization payment. Calculating this accurately in 2026 requires real-time valuation of foreign real estate and an understanding of fluctuating exchange rates, all while ensuring the transfer does not trigger international money laundering red flags. As we move through this financial maze, it becomes clear that the numbers on the page are only half the story. The way these financial decisions are communicated to the community can determine a person's social standing for years to come. A man who is seen as withholding a mahr or a woman who is seen as taking more than her religious share can face intense social repercussions. This brings us to the hidden engine of the divorce process: the social network and the community gossip mill. In the next part, we are going to explore the psychological warfare of the communal divorce. We will look at how the masjid becomes a battleground, the role of WhatsApp groups in shaping the narrative of a split, and the devastating impact of social stigma on the mental health of American Muslim divorcees in 2026. We will also examine how a new generation of community leaders is fighting back against this stigma to create a more supportive environment for those starting over. The social machinery that follows a divorce in the American Muslim community of 2026 is often more efficient and more ruthless than the legal system itself. While the court handles the division of property, the community handles the division of reputation. In 2026, the traditional anti-network has migrated from the telephone to encrypted messaging apps like Signal and WhatsApp, creating a digital majlis where a person's social standing can be dismantled in the time it takes to send a voice note. To understand the psychological and social toll of this process, we have to look at how social capital is liquidated during a split. In many tight-knit communities in cities like Houston, Chicago, or Patterson, your identity is not just as an individual, but as a half of a whole. When that union breaks, you are not just losing a spouse, you are losing your membership in a specific social ecosystem. Consider the case of Amina, a 34-year-old digital marketing professional living in suburban Houston in 2026. For 10 years, Amina and her husband were the gold standard of the young professional Muslim couple. They were active in the masjid, led youth programs, and hosted community dinners. When they decided to separate, the social fallout was instantaneous. Step by step, the isolation began with a quiet split. This is the period where only immediate family knows, and a fragile peace is maintained. But in a community where everyone is connected, the silence is short-lived. The second step is the leak. It usually begins with a small observation. Amina's husband attending Friday prayer alone for 3 weeks straight, or a missing wedding ring. In the digital age of 2026, this observation is instantly amplified. Amina found herself the subject of a massive community-wide discussion on a local Telegram group before she had even filed her civil paperwork. Historical trends show that in the American Muslim diaspora, the burden of social stigma is disproportionately carried by women. Case studies from 2026 indicate that while a divorced man is often encouraged by his peers to remarry quickly to maintain his religious half of the faith, a divorced woman is often viewed through a lens of skepticism or pity. Amina's experience mirrors this. She reported that her female friends, many of whom were also married, slowly began to distance themselves. This is a documented social phenomenon where the divorcee is seen as a reminder of the fragility of everyone else's marriage. Imagine if your entire support network, the people you called in emergencies and celebrated holidays with, suddenly viewed you as a social liability. This isolation is not just about missing dinner parties. It has real-world consequences for mental health, leading to documented spikes in anxiety and depression among Muslim divorcees who feel they have nowhere to turn. Now, imagine the perspective of the husband in this scenario, whom we will call Zaid. Living in Chicago in 2026, Zaid faces a different but equally taxing set of social pressures. While he might not face the same level of ostracization as Amina, he is subject to the brother's circle pressure. In many men-only spaces, there is a cultural expectation to remain stoic and to avoid discussing the emotional fallout of the divorce. This lack of emotional outlet often leads to a different kind of crisis. Zaid might find himself being pushed into a new marriage before he has processed the trauma of a historical trend that often leads to a cycle of high-conflict relationships. Potential outcomes for men in Zaid's position often include a total detachment from the masjid community because the physical space itself, the place where he used to stand next to his father-in-law in prayer, has become a site of intense psychological discomfort. The physical space of the masjid in 2026 has become a literal battleground for narrative control. Step by step, we see how this plays out. First, there is the avoidance of the main hall. A divorcee might start attending a different masjid 20 miles away, just to avoid the awkward stares and the inevitable questions. Second, there is the gatekeeping of leadership roles. Case studies show that individuals going through a divorce are often quietly asked to step down from board positions or teaching roles in the Sunday school. The rationale given is usually to give them time to focus on their family, but the impact is a loss of agency and purpose. In Amina's case, her halal catering business, which relied heavily on community contracts, saw a significant drop in bookings. This is where social stigma becomes a financial weapon, as community members may choose to stop supporting a business as a way of taking sides in the divorce. In response to these harsh realities, The landscape of 2026 is seeing the rise of professionalized support systems. We are seeing a historical shift where imams are no longer expected to be the sole counselors for a couple. Instead, many modern American masjids are partnering with licensed Muslim therapists to provide a dual-track approach. This involves pastoral care from the imam to address spiritual questions and clinical therapy to address the trauma of the split. These support groups are creating a new tribe for individuals like Amina and Zaid. Step by step, these groups are working to destigmatize divorce by framing it not as a religious failure, but as a difficult life transition that requires communal empathy rather than judgment. Data from 2026 suggests that communities with these integrated support systems see much higher rates of healthy post-divorce reintegration. However, the digital footprint of a divorce in 2026 adds a layer of complexity that previous generations never faced. Every court filing in the United States is a matter of public record. A curious community member with a laptop and a few dollars for a record search can find out the intimate details of a couple's financial disputes, their allegations of misconduct, and their custody arrangements. This transparency is a double-edged sword. While it can hold people accountable, it also means that a private family tragedy becomes public entertainment. We are seeing a rise in digital defamation cases where one spouse sues the other, or even a third-party community member, for spreading information gathered from these public records on social media. This turns the divorce into a permanent, searchable stain on a person's reputation, affecting their future job prospects and even their ability to find a new spouse. The psychological warfare of the communal divorce also extends to the children. In 2026, children of divorced Muslim parents are often caught in the middle of these community narratives. They may hear rumors at school or at the masjid about why their parents split. This communal gossip can undermine the parenting plans we discussed earlier, as it introduces external conflict into the children's lives. Imagine if a child is told by a well-meaning, but intrusive community member that their mother is at fault for the divorce because she was too focused on her career. This creates a loyalty conflict that can take years of therapy to resolve. To counter this, 2026 parents are increasingly signing non-disparagement agreements that apply not just to the parents, but to their extended families and social circles as well. As we conclude this part of the masterclass, it is clear that the social and psychological dimensions of divorce are just as regulated as the legal and financial ones, albeit by unwritten codes. The 2026 American Muslim experience is defined by a struggle between traditional communal values and the modern reality of individual autonomy. We have seen how reputation is managed, how the masjid is navigated, and how digital platforms have changed the stakes of social survival. But even as the social dust settles, a new and perhaps more dangerous battle often emerges. It is a battle that takes place in the dark corners of the legal system, where one party seeks not just a divorce, but total control over the other's spiritual and physical freedom. In the next part, we are going to explore the high-stakes world of spiritual abuse and domestic litigation. We will look at how the civil courts are beginning to recognize the concept of religious coercion and the legal strategies used to protect victims when a marriage turns into a cage. We will examine the specific 2026 case law that is redefining the boundary between religious freedom and individual safety. The concept of religious coercion and spiritual abuse is no longer a hidden struggle discussed only in hushed tones behind closed doors. In 2026, it has become a focal point of American family law litigation. To understand the gravity of this shift, we must look at how United States courts are navigating the delicate balance between the First Amendment's protection of religious exercise and the state's compelling interest in protecting citizens from domestic harm. Historically, judges were hesitant to touch anything that looked like a religious dispute, fearing they would overstep their constitutional bounds. However, historical trends show that as of 2026, several key states, including California, New York, and Hawaii, have expanded their definitions of domestic violence to explicitly include coercive control. This legal evolution has opened the door for attorneys to argue that religious manipulation is not a protected expression of faith, but a documented form of psychological and spiritual abuse. Imagine the scenario of a woman named Layla living in Northern Virginia in 2026. Layla has been married to her husband, Adam, for 12 years. When Layla expresses her desire for a divorce due to irreconcilable differences, Adam doesn't just object on personal grounds. He begins a campaign of spiritual intimidation. He tells Layla that by seeking a civil divorce, she is placing her soul in eternal jeopardy, and that according to his interpretation of their faith, her parents will be held responsible for her sins in the afterlife. He goes further, contacting their local imam and several influential families in their community to label Layla an apostate. In the past, a U.S. court might have viewed this as a private religious matter. But in 2026, Layla's legal team can present this as a case study in coercive control. They can argue that Adam is using the specific leverage of Layla's religious identity and social standing to intimidate her into remaining in a marriage against her will. Step by step, the legal strategy in such cases involves documenting how the religious narrative is being used to achieve a secular advantage. If Adam tells Layla he will only grant her a religious divorce or khula, if she waives her right to the equity in their family home or gives up her court-ordered child support, this moves from the realm of theology into the realm of extortion. Potential outcomes for a case like this in 2026 include the court issuing a protective order that specifically prohibits the abusive spouse from using religious shaming or community pressure as a tool of harassment. We are seeing case studies where judges have granted Layla exclusive use of the family home and prohibited Adam from contacting their religious leaders for the purpose of disparaging her character. This is not the court interpreting Sharia. It is the court interpreting Adam's behavior as a violation of civil safety standards. The intersection of the First Amendment and personal safety becomes even more complex when we discuss the withholding of a religious divorce as a form of spiritual abuse. In the Jewish community, this is known as the get, and several states have passed laws to prevent a spouse from using the refusal of a religious divorce as a bargaining chip. By 2026, these get laws are being used as a historical precedent for Islamic divorce cases. If a husband refuses to acknowledge the end of a marriage religiously after a civil decree has been issued, he is effectively trapping the wife in a limping marriage. Lawyers are now using expert witnesses, theologians and scholars with dual degrees in Islamic and U.S. law to testify in civil court. These experts do not tell the judge which religious view is correct. Instead, they provide the cultural context necessary for the judge to understand that the refusal is a deliberate act of power meant to cause psychological harm. In a 2026 appellate court case in New Jersey, the court looked at whether a husband's persistent refusal to grant a religious divorce, despite a civil judgment of absolute divorce, could be considered in the distribution of assets. The potential outcome of this shifting legal philosophy is that a judge may award a larger share of the marital estate to the wife as a form of compensation for the ongoing psychological distress and social limitations imposed by the husband's refusal to release her. This represents a massive departure from the non-entanglement doctrine of the 20th century. It shows a judicial system that is becoming increasingly literate in the nuances of minority religious practices and the ways those practices can be weaponized in domestic disputes. Furthermore, we must examine the physical reality of the masjid as a site of potential trauma and legal protection. In 2026, stay-away orders and domestic violence injunctions are being drafted with unprecedented specificity. Imagine if Layla's protective order against Adam specifically mentions their local Islamic center. In the past, an order might simply say to stay away from the victim's workplace or home. Today, 2026 judges are willing to include religious institutions in these orders, stipulating that Adam must not attend the same Friday Jummah prayer as Layla or must remain a certain distance from the specific areas of the masjid where women and children congregate. This requires the masjid administration to be informed of the civil legal situation, creating a bridge between the secular court and the religious community that was once non-existent. The role of the forensic psychologist has also changed. In 2026, when assessing a family for a custody or abuse case, these professionals are trained to identify spiritual abuse. They look for signs that a parent is using religious fear to alienate a child from the other parent. If Adam tells the children that their mother is no longer a true believer because she chose to live in a separate apartment, this is flagged as parental alienation through religious indoctrination. The step-by-step documentation of these conversations becomes evidence in a custody hearing, where a judge might limit Adam's legal custody, his right to make decisions about the children's religious upbringing, because he has proven he uses religion as a weapon rather than a foundation for the child's well-being. Data from 2026 legal clinics suggests that victims of spiritual abuse are often the most difficult to help because they feel they are betraying their faith by seeking secular protection. This is why the rise of culturally competent legal aid has been so vital. These organizations provide a framework for individuals to understand that their religious rights do not include the right to be abused. They help survivors like Layla navigate the dual process of obtaining a civil restraining order while simultaneously petitioning a Sharia council for a fash or judicial annulment. This pincer movement, using the civil court for physical and financial safety and the religious council for spiritual freedom, is the standard of care for 2026. As we look at the potential outcomes of these high-stakes battles, it is clear that the definition of a safe home has expanded. It now includes safety from the misuse of the divine to justify the terrestrial. This transition from a cage of religious justification to the freedom of legal autonomy is the most profound shift in the modern American Muslim experience. But once the legal battle is won and the protective orders are signed, the survivor faces a new, quieter challenge: the period of transition. In the next part, we are going to explore the forgotten months of the iddah, the waiting period. We will look at the psychological and physical realities of this 3-month transition, the modern 2026 interpretations of how it should be observed in a working professional's life, and why this period is often the most dangerous time for a woman's financial and physical security. We will explore how 2026 families are redefining this ancient tradition for a modern American context. The concept of iddah, or the waiting period, is often misunderstood by the public as a mere formality, but in the landscape of 2026 American family law, it represents a high-stakes bridge between religious obligation and civil legal status. Traditionally, iddah is the period a woman observes after the dissolution of her marriage, lasting approximately 3 menstrual cycles or 3 months for a non-pregnant woman. In 2026, the application of this ancient tradition has been forced to evolve to accommodate the realities of the American working professional. To understand this transition, let us look at the case study of Sarah, a senior marketing executive in Chicago. In 2026, Sarah and her husband Michael have decided to end their marriage. Under Islamic law, once the divorce is pronounced, Sarah enters her iddah. The primary religious purposes of this period are twofold. First, to establish whether the wife is pregnant to ensure the clarity of paternity, and second, to provide a cooling-off period where reconciliation is still possible. Step by step, the first challenge Sarah faces is the conflict of residence. In traditional Islamic jurisprudence, a woman is expected to remain in the marital home during her iddah, and the husband is religiously obligated to provide this housing. However, in a 2026 U.S. context, this creates immediate civil legal tension. If Sarah has filed for a civil protective order, or if the state of Illinois has issued a temporary exclusion order requiring Michael to leave the home due to domestic conflict, the religious requirement of staying in the shared residence becomes a point of contention. Historical trends show that in 2026, many U.S.-based imams and Sharia councils are issuing revised guidance, stating that the safety and legal mandates of the state take precedence. If Sarah's physical or mental safety is at risk, her iddah can be observed in a separate, secure location without violating the spirit of the law. This shift reflects a community that is prioritizing the preservation of life over a literalist interpretation of domestic arrangements. Imagine if Sarah attempted to observe a traditional, secluded iddah while maintaining her role at a major corporation. In some historical interpretations, a woman in iddah is encouraged to limit her social interactions and avoid unnecessary travel. For a 2026 professional, this is often impossible. Sarah cannot simply vanish from her boardroom for 90 days without risking her career and her financial independence. Consequently, we see a rise in the definition of meaningful iddah. Scholars in 2026 are increasingly emphasizing that for the working woman, her employment is a necessity. Therefore, her iddah involves a commitment to emotional reflection and avoiding new romantic pursuits, rather than a total withdrawal from public life. Step by step, Sarah manages her daily routine by fulfilling her professional obligations while dedicating her private time to the spiritual and psychological processing of the divorce. The second major pillar of the iddah is financial maintenance, known as nafaqah. Under Islamic law, Michael is responsible for all of Sarah's living expenses, housing, food, clothing, and medical care, until the iddah concludes. In a U.S. courtroom in 2026, this often overlaps with pendant light support, which is temporary support granted while a divorce is pending. Case studies from 2026 show that clever attorneys are now aligning these two concepts. A lawyer representing Sarah might argue that Michael's religious obligation to pay nafaqah should be formalized into the civil court's temporary support order. This ensures that the religious duty is backed by the power of the state. If Michael fails to provide for Sarah during these 3 months, he is not just failing a religious test. He is in contempt of a U.S. court. This integration provides a safety net for women who might otherwise be financially coerced during the most vulnerable stage of the separation. Data from 2026 indicates that the iddah is statistically the most dangerous time for a woman's physical security. This is because the period immediately following a pronouncement of divorce is when a controlling or abusive spouse feels the greatest loss of power. In the American Muslim community, this risk is sometimes heightened by the cultural pressure to remain in the same house for the duration of the iddah. Step by step, safety experts in 2026 are working with masjids to create safe exit plans. These plans involve digital security, such as changing passwords on shared accounts and installing smart home monitoring systems that can be accessed by the wife alone. We see case studies where 2026 courts have specifically cited the religious iddah period as a justification for extending a temporary restraining order, acknowledging that the transition period requires heightened vigilance. The complexity intensifies if the woman is pregnant. In this scenario, the iddah does not end in 3 months. It continues until the birth of the child. For a 2026 family, this means the religious and civil timelines can be years apart. If a woman is in her first trimester when the divorce occurs, she remains in a state of iddah for another 6 to 7 months. During this time, the husband's obligation to provide nafaqah continues. In U.S. civil law, this intersects with the complexities of prenatal support and the determination of birth expenses. Historical trends show that 2026 judges are increasingly willing to look at the religious contract to determine how the parties intended to handle these costs. If the nikah specified that the husband would cover all costs associated with the iddah, a judge may hold him to that higher standard of care, even if state law is more restrictive. We must also address the biological reality of paternity in 2026. While the original intent of the 3-month iddah was to ensure there was no confusion regarding the father of a child, modern DNA testing has made this specific biological concern less urgent from a scientific perspective. However, the social and religious weight of the period remains. For many in the American Muslim community, the iddah is not just about biological certainty. It is about a period of transition and respect for the gravity of the contract that is being dissolved. Potential outcomes for couples who ignore the iddah can include social stigmatization or the refusal of a religious authority to perform a subsequent marriage for the wife if she remarries too quickly. In 2026, we are also seeing the emergence of iddah coaching. These are specialized consultants who help women navigate the logistics of these 3 months. They provide a step-by-step framework for managing family expectations, handling the awkward transition of social circles, and ensuring that the religious requirements are met in a way that is compatible with the modern U.S. lifestyle. For example, a coach might help Sarah draft a professional communication for her HR department that explains she is going through a family transition that may require some flexibility in her schedule, without necessarily disclosing every religious detail. The financial security of the wife during iddah is also tied to the deferred mahr we discussed earlier. In many cases, the payment of the deferred mahr is triggered by the start of the iddah. In 2026, we see disputes over whether this payment constitutes a lump sum alimony or a separate contractual debt. If Michael pays the mahr at the start of the iddah, does he still owe monthly nafaqah? Most scholars in 2026 agree that the mahr is a separate right and does not replace the husband's duty to provide for the wife's daily needs during the waiting period. This dual financial requirement can be a significant burden for the husband, and case studies show that it often leads to intense negotiations in the civil mediation process. As the iddah draws to a close, the finality of the divorce begins to set in. This is the moment where the social and spiritual path of the individual truly diverges from their former life. Iddah is the final chapter of the marriage, but it is also the prologue to the next phase of life. But what happens when the 3 months are over? What is the reality of the American Muslim dating and remarriage scene in 2026? How do you negotiate a new nikah contract when you are carrying the scars and the legal baggage of a previous one? In the next part, we are going into the deep dive of life after divorce. We will explore the controversial world of professional matchmakers, the rise of the pre-vetted marriage profile, and the specific 2026 strategies for drafting a second marriage contract that protects you from repeating the mistakes of the past. We will look at how the community is evolving to support those who are starting over, and the new legal safeguards being used to ensure that a second chance at happiness is built on a foundation of clarity and transparency. Entering the dating and remarriage market in 2026 as an American Muslim divorcee is a fundamentally different experience than it was even 5 years ago. The community has moved past the era of silent shame and into an era of radical transparency and legal preparedness. If part 1 through 8 of this series taught us anything, It is that the lack of clarity in the first marriage is often what leads to the catastrophic fallout of the divorce. In 2026, the second-timers, individuals who have already navigated the civil and religious legal systems, are the ones driving a revolution in how Islamic marriage contracts are drafted. They are no longer looking for a ceremonial document. They are looking for a robust, lawyer-vetted framework that protects their children, their assets, and their peace of mind. Imagine a character named Marcus, a 40-year-old software engineer in Austin, Texas. Marcus finalized his divorce in 2024, a process that cost him tens of thousands in legal fees and a significant portion of his retirement savings due to a poorly defined mahr and a lack of a prenuptial agreement. Now in 2026, Marcus is ready to remarry, but the social landscape has shifted. He is no longer just looking at a potential spouse's personality or religious practice. He is looking at their legal compatibility. This has led to the rise of the pre-vetted marriage profile. In 2026, high-end Muslim matchmaking services in the U.S. now offer, and sometimes require, a background check and a financial disclosure summary before a first meeting is even facilitated. This is not about a lack of trust. It is about the historical trends of 2026, showing that transparency at the outset is the greatest predictor of long-term stability. Step by step, the vetting process for a second marriage in 2026 involves 3 distinct layers. First, there is the social verification. Because the community is so interconnected, matchmakers now use formal reference checks, reaching out to previous imams or community leaders to ensure that any past domestic issues or religious disputes have been resolved. Second, there is the clinical layer. Many 2026 couples are opting for joint therapy sessions before the nikah to discuss the baggage of their previous marriages. They are using licensed Muslim therapists to identify patterns that might lead to a repeat of past conflicts. Third, and most importantly for this masterclass, is the legal layer. Potential outcomes for Marcus in 2026 include a requirement to present his final divorce decree and his religious fash or talaq papers to his new spouse's family. This ensures there is no lingering limping marriage situation that could haunt the new union. The drafting of the second nikah contract in 2026 is where we see the most innovation. Imagine if Marcus is marrying Fatima, who also has 2 children from a previous marriage. Their contract will not be a one-page template. It will be a comprehensive multi-page document that functions as a companion to a civil prenuptial agreement. One of the most critical elements in a 2026 second marriage is the wasiyah, or the Islamic will. Under Islamic inheritance law, a new spouse has a mandatory share of the estate. However, in a blended family, this can create a conflict with the inheritance rights of children from a previous marriage. To solve this, 2026 couples are using the 1/3 rule of the wasiyah to direct assets specifically to their biological children, while using US-based living trusts to ensure that the family home or specific investments are protected. They are aligning their religious desire to follow Islamic inheritance with the US legal tools that allow for specific asset protection. Case studies from 2026 highlight a significant increase in the use of the conditional mahr in second marriages. Unlike a first marriage, where the mahr is often a large, symbolic deferred sum, second-timers are opting for more pragmatic arrangements. Marcus and Fatima might agree on a prompt mahr that is invested into a Sharia-compliant education fund for their children, or they might stipulate that the deferred mahr is only payable if the divorce is initiated by the husband without cause. This level of granularity is a direct response to the financial trauma many experienced in their first divorces. They are treating the mahr not just as a gift, but as a strategic financial tool that provides security without creating an impossible debt for the husband. The role of children in these new unions creates another layer of legal complexity. In 2026, the concept of the blended family, the American Muslim Brady Bunch, is becoming a standard part of the community fabric. However, the legal and religious roles of a step-parent are often in conflict. In Islam, a stepfather does not replace the biological father in terms of guardianship or wilaya. In U.S. law, a step-parent has very few rights unless they formally adopt the child. This creates a friction point in 2026 when it comes to daily decision-making. We see case studies where 2026 parenting plans include a delegation of authority clause, where the biological father agrees to allow the stepfather to pick the children up from school or attend medical appointments. This is a pragmatic way to navigate the best interests of the child standard, while respecting the religious boundaries of biological lineage. Furthermore, we must discuss the rise of the mediation first clause in the 2026 nikah. Having seen how expensive and destructive a civil court battle can be, many second-timers are writing a mandatory mediation period into their religious contract. This clause stipulates that before either party files for a civil divorce, they must undergo 90 days of mediation with a pre-approved board of both legal and religious experts. The goal is to reach a settlement on all major issues, custody, mahr, and asset division, in a private, less adversarial setting. Historical trends in 2026 show that these clauses are being honored by U.S. judges, who generally prefer that families resolve their disputes outside of the courtroom whenever possible. Data from 2026 indicates that second marriages in the American Muslim community that utilize these hyper-detailed contracts and vetting processes have a significantly lower rate of secondary divorce. This is likely because the honeymoon phase is tempered by a realistic understanding of the legal and financial stakes. For individuals like Marcus and Fatima, the goal of the 2026 marriage is not just love, but a partnership built on a foundation of mutual protection. They are using the lessons learned from their first divorces to build a more resilient second union. They are proving that you can be both deeply religious and legally savvy. The social integration of the second marriage is also evolving. In 2026, we see the rise of blended family support groups in major hubs like Dallas and New York. These groups provide a space for step-parents to discuss the unique challenges of their roles, and for children to see that they are not alone in their experiences. The stigma of the second marriage is being replaced by a celebration of resilience. However, even with all these safeguards, the process of starting over is not without its risks. The psychological impact of a first divorce can linger, and the pressure to make the second marriage work can sometimes lead to a person ignoring red flags. As we reach the conclusion of this part of our masterclass, it is clear that the second chance at happiness in 2026 is a calculated, deliberate endeavor. It requires a mastery of both the spiritual and the secular, a willingness to be transparent about the past, and a commitment to protecting the future through the power of the written word. But as we look at the entire landscape we have covered, from the first signing of the nikah to the final decree of the civil court and the eventual search for a new beginning, one question remains. What is the ultimate takeaway? How do we synthesize all this data, all these case studies, and all this legal complexity into a single, actionable philosophy for the American Muslim family? In the final part of our deep dive masterclass, we are going to pull it all together. We will look at the future of Islamic law in the United States, the upcoming legislative changes that could redefine everything we have discussed, and the final set of strategies every family needs to thrive in 2026 and beyond. This is the grand finale of our series, where the map of the modern American Muslim experience is finally completed. As we complete this map of the modern American Muslim experience in 2026, we must look at the legislative horizon and the emerging legal technologies that are fundamentally altering the way divorce is navigated. The final set of strategies for any family to thrive involves moving beyond reactive litigation and toward a model of proactive legal and spiritual hygiene. We are currently witnessing a historical shift in the United States, where several state legislatures are debating or have already passed versions of the Uniform Family Law Arbitration Act. In 2026, this act provides a standardized framework for how religious arbitration, including decisions made by Sharia councils, can be recognized and enforced by civil courts. This is a game changer because it moves the religious divorce out of the realm of unenforceable social contracts and into the realm of formal, state-sanctioned alternative dispute resolution. To understand how this functions in a real-world scenario, imagine a case study involving a couple in Washington state named Omar and Layla. In early 2026, they decide to end their marriage but want to avoid a scorched earth battle in the public court system. Because their state has adopted the new arbitration standards, they can sign an agreement to submit their mahr and asset division disputes to a recognized panel of Muslim jurists and civil attorneys. Step by step, the process begins with the selection of the arbitrator, followed by a formal hearing where evidence is presented, just as it would be in a courtroom. The potential outcome is a binding arbitration award that a civil judge can then confirm as a legal judgment. This process preserves the religious integrity of the decision, while providing the finality and enforcement power of the United States government. This is the 2026 gold standard for minimizing communal trauma and maximizing legal certainty. Furthermore, we must address the professionalization of the American imam. In 2026, we are seeing a historical trend where the role of the religious leader is being bifurcated. The days of a single volunteer imam acting as a judge, jury, and counselor are fading. In their place, we see the rise of the professional mediator. Large masjids in hubs like Southern California and Northern Virginia are now requiring their resident scholars to complete a minimum of 40 hours of state-certified mediation training. This ensures that when a couple comes to them for a religious divorce, the imam is equipped to identify signs of domestic violence, power imbalances, and financial coercion. Case studies from 2026 indicate that this professionalization has led to a 40% reduction in post-divorce litigation, as couples are guided toward fair settlements before they ever step foot in a courthouse. This professionalization is also driven by a new reality: imam liability insurance. In 2026, religious leaders who issue divorce decrees or mediate financial disputes are increasingly seeking insurance coverage to protect themselves from lawsuits alleging malpractice or spiritual abuse. This has forced Sharia councils to adopt rigorous, lawyer-vetted standard operating procedures. Imagine if an imam in 2026 grants a fash, or judicial annulment, without properly notifying the husband or following due process. Under the new legal climate, that imam could be held liable in a civil court for damages. Consequently, the 2026 religious divorce is documented with a level of precision that mirrors a civil trial, with formal notices, recorded testimonies, and written opinions that cite both Quranic precedent and U.S. case law. The technological dimension of 2026 also introduces the concept of digital jurisprudence. AI-driven legal assistants are now capable of cross-referencing centuries of Islamic legal opinions with modern U.S. state statutes in seconds. Imagine a lawyer in 2026 who is arguing a complex child custody case. They can use an AI tool to find the specific intersection of Hadhana traditions and the best interests of the child standard in Florida appellate rulings over the last 20 years. This technology allows for the creation of hyper-specific legal briefs that speak the language of both the civil judge and the religious community. For the average family, this means that the cost of navigating this dual system is potentially decreasing as the research becomes more automated and accessible. However, the 2026 landscape also presents new challenges, specifically regarding digital assets. We are seeing case studies where the mahr is defined in cryptocurrency, or where the marital estate includes high-value NFTs and virtual real estate. In 2026, the valuation of these assets during a divorce is a forensic nightmare. If a nikah contract from 2021 specified a mahr of 10 Bitcoin, and the divorce occurs in 2026, the dollar value has fluctuated wildly. U.S. courts are currently struggling with whether to enforce the specific asset or its cash equivalent at the time of the signing. The strategy for 2026 is to include a valuation cap, or a currency peg in the marriage contract to prevent a volatile market from turning a symbolic gift into a financial catastrophe for one party. Step by step, the proactive nikah strategy for 2026 and beyond involves what we call the triad approach. This requires the involvement of 3 distinct professionals before the wedding even takes place: a family law attorney to draft a civil prenuptial agreement, a qualified religious scholar to ensure the nikah is spiritually sound, and a financial advisor to structure the mahr and asset division in a tax-efficient manner. Historical trends show that couples who utilize this triad approach are significantly more likely to have a peaceful resolution if the marriage ends. They are not leaving their future to chance or to the interpretation of a judge who may not understand their culture. They are taking ownership of their legal and spiritual destiny. We must also acknowledge the shift in communal health. In 2026, the stigma of divorce is being actively dismantled by a new generation of community leaders who view divorce not as a failure of faith, but as a potential necessity for safety and well-being. We see the rise of divorce recovery groups within the masjid, where men and women can find mentorship and support during the iddah and beyond. These groups provide a counter-narrative to the gossip mill, emphasizing that the end of a marriage is a transition that requires the entire community's empathy. This cultural shift is vital because it reduces the isolation that often leads individuals to make poor legal or financial decisions out of desperation or shame. Looking at the global context, the American Muslim experience in 2026 is becoming a model for other Western nations. The way the U.S. legal system has adapted to recognize Islamic contracts through the lens of neutral contract law is being studied by legal scholars in the UK, Canada, and Australia. This cross-pollination of legal strategies means that the 2026 American Muslim is part of a global movement toward a more sophisticated, dual-literate approach to family law. The goal is a world where faith and citizenship are not in conflict, but are harmonized through clear, transparent, and enforceable agreements. As we conclude this deep dive masterclass, the final lesson is one of empowerment through knowledge. The complexities we have explored, From the nuances of the mahr to the psychological weight of the iddah and the high-stakes battles over child custody, are not reasons for fear, but calls for preparation. In the modern United States, your religious identity and your legal rights are not mutually exclusive. By understanding the machinery of both systems, you can navigate even the most difficult life transitions with dignity and clarity. This concludes our 10-part series on the intersection of Islamic law and the U.S. legal system. But as one chapter ends, another begins. What happens when the focus shifts from the end of a family to the beginning of a legacy? In our next deep dive series, we will explore the 2026 revolution in Islamic estate planning and wealth transfer in the U.S. We will look at how the next generation is using Sharia-compliant trusts and digital inheritance tools to build a legacy that lasts for centuries. How do you protect your wealth and your values when the legal landscape is shifting beneath your feet? The answers are in the next part of the journey.